multiple sexually violent predators are eligible for release. They're being placed, a lot of them, in San Diego's East County.
Many community members have been expressing a lot of concern and worry over the matter. And here to give us his take on the situation is political analyst Vikas Bajaj. Good to see you.
Likewise. Thank you so much.
So we know East County is remote. We know that a lot of these sexual predators, after they've served their time, their sentence, are being dumped in this area. What is the reason that that is the place?
Excellent question. Let me back up and just tell you why these offenders are still incarcerated. There's a criminal punishment, so our legislators say if you commit a certain crime, you have to spend a certain number of years or months in prison. Once that's done, or at least 45 days before the release of individuals who have committed certain types of sexual offenses, the Department of State Hospitals actually has two clinicians evaluate the individual to say, well, is this a person who actually can be released safely into the community, okay? And when that happens, that starts a sexual violent predator labeling. It can either be done by the district attorney's office or uniquely by the Department of State Hospitals. And what happens then is if there is an affirmative finding that the individual needs more treatment, should not be released because of a harm to the society and our community, well, then there's a whole different civil commitment that happens, not criminal, but civil. And so what happens is there's 5 phases of this treatment for SVPs, or sexually violent predators. And once they've graduated this therapy and getting on with the program, which requires a full allocution of what they did in the past, what their potentially lewd and lascivious desires may be, then they can graduate to phase 5, when they become eligible for conditional or unconditional release. So it's important to know that we're dealing within the Welfare and Institutions Code, a civil code. We're not dealing with the criminal punishments. So the decision on where to house individuals that have been declared SVPs is purely, in my opinion, a financial decision, because there are large private groups that run the counseling, GPS monitoring, and counter surveillance in addition to the Sheriff's Department.
$1 million a year, you mentioned it costs just to watch one predator.
You know, that's correct. And I talked to 3 people that practice in this area and other parts of our fine state of California, and each of them gave me that number or a higher number. Because you have to understand, while these individuals are housed in an area that is jurisdictionally supervised and surveilled by our county sheriff's department, there are private funds for surveillance, GPS, polygraphs every 90 days, random checks, random psychological evaluations. So it's not a very inexpensive task to have individuals monitored.
Do residents have any recourse in the East County or other places to say, keep these predators out of my neighborhood?
Yes, and what you see is what's happening now. The locals are saying this is not appropriate. Not only is it a disproportional representation of placement of SVPs in our community, but we just don't want it in our backyard. And that's really what it comes down to. So you see in our case today, Judge Hartunian has taken it under submission because of the force and effect of the victims coming forward and saying, well, you know, this cannot happen. He or she is still a danger.
The judge has said in the case of Alvin Quarles that he has the right, this defendant, to fail. He has the right to fail. Yes. Legally, how is it that his rights are put ahead of the innocent people who live in East County who are frightened that he's going to be living in their neighborhood?
Well, that argument really needs to be taken up with our state legislators, because our state legislators decide what the punishments will be under our California Penal Code. Then, of course, they decide what the rights will be under the Welfare and Institutions Code, which continues on into the civil arena as we're discussing now. It's a problem with the law. The problem is any judge or magistrate deciding fact in a case like this is presented with expert testimony. Clinicians, retained or publicly paid for, experts who can say forensically this person poses a risk or does not pose a risk. If the judge or the court has to only rely upon the evidence that is presented to him or her, well, they're in a bad position. Because if the evidence and the experts, which could be privately retained, as I say, or otherwise financially motivated for continuing treatment, if that is all the evidence, the law does not give the judge a right to say, I'm going to consider the totality of the circumstances, and it just doesn't sit right. So it's really a problem, in my opinion, with the law, and it puts a lot of our fine judges in a terrible situation.
Got to follow the law. Vic Bajaj, great to have you on the program.
Yeah.
Thank you so
Great
much
information.
for helping us
Thank
understand
you.
all of that.
Thank you.